Section 26. Legal issues, customer or client, or no representation. That is the question. When the details matter. By this point in the course, you have probably noticed that agency issues are rarely caused by one major mistake. Most problems begin with small details: a missing signature, a vague compensation term, a buyer agreement that is too narrow, a dual agency conversation that happened too late, a seller who refuses to close unless the brokers reduce their commission, a buyer who wants to see properties but it's not clearly agreed how their agent will be paid. These are the situations where Arizona licensees must slow down and think. Agency law is not just theory. It shows up in real files, real negotiations, real commission disputes, and real conversations with clients. Be careful when completing the BBEA. When completing the buyer-broker exclusive employment agreement, be careful not to make the agreement unnecessarily narrow. For example, if the buyer tells you they are only looking in Gilbert, you may be tempted to write Gilbert only into the agreement. But what happens if that buyer later purchases in Mesa, Chandler, Queen Creek, or Santan Valley through another agent? If your agreement was limited too tightly, you may have created a problem for yourself. The same concern may apply to specific square footage, number of bedrooms, property type, or other narrow limitations. That does not mean you should ignore the buyer's preferences. Of course, you should understand what they want. But your buyer search criteria and your employment agreement do not have to be the same thing. The agreement should be completed carefully and in accordance with your broker's policy. Every word matters. Can a broker be forced to reduce commission? Now imagine this situation. A seller has accepted an offer. The transaction is in escrow. The buyer has completed inspections. The lender is close to final approval. Everyone is preparing for closing. Then, at the last minute, the seller says, "I will not close unless the brokers reduce their commission." This puts everyone under pressure. The buyer wants the house. The seller is threatening the transaction. The agents want the closing to happen. But does the listing broker have a fiduciary duty to reduce the agreed commission just to make the seller happy? No. A broker is not required to give up compensation that was properly negotiated in an employment agreement, simply because a party later changes their mind. If the seller refuses to close, the seller may be in breach of contract with the buyer. The listing broker may also have rights under the listing agreement. That does not mean litigation is the preferred outcome. Most brokers would rather resolve the issue professionally if possible. But legally and ethically, a broker is not automatically required to reduce commission to rescue a transaction. Commission disputes between licensees. Arizona Commissioner's Rule R4-28-1101D reminds licensees that they cannot allow a controversy with another licensee to jeopardize, delay, or interfere with a transaction on behalf of a client. That rule is especially important in procuring cause and compensation disputes between brokers. In plain English, do not let your fight over commission harm the client's transaction. If two brokers disagree over who should be paid, that dispute can usually be handled later through the broker, mediation, arbitration, or legal process. The client's transaction should not be held hostage. However, that rule does not require a broker to change the terms of an employment or compensation agreement. It also does not prevent a broker from later pursuing a legitimate claim. Implied agency during a listing presentation. Another legal issue involves listing presentations. Suppose you meet with a seller to discuss listing their home. During the appointment, the seller shares sensitive information about finances, motivation, family circumstances, or the lowest price they would accept. The seller later decides not to list with you and hires another brokerage. Did an agency relationship automatically exist just because you attended the listing presentation? Usually, no. A listing presentation alone does not normally create agency. Agency generally requires conduct showing mutual intent to create the relationship. However, you should still be careful. If your words or actions cause the seller to reasonably believe you are already representing them before a listing agreement is signed, an implied agency argument could arise. The better practice is to explain early. Until we enter into a written listing agreement, I am here to discuss the possibility of representation, but our agency relationship has not yet been created. That simple statement helps prevent confusion. Comparable sales and seller representation. Now let's look at another common question. You represent a seller who insists on listing the home above your recommended price. A buyer asks you for comparable sales that suggest the property is overpriced. Do you have to provide those comparables to the buyer? If you represent only the seller, your fiduciary duty is to the seller. Your job is to protect and promote the seller's interests while still being honest and fair to the buyer. You must disclose known material facts when required by law. But ordinary comparable sales information is not usually the same thing as a hidden defect or material adverse fact affecting the property. If giving the buyer your pricing analysis would harm your seller's negotiating position, you should be very cautious and follow your broker's policy. A buyer who wants pricing advice should obtain their own representation. Comparable sales in dual agency. Dual agency changes the analysis. If you are acting as a limited dual agent and you possess non-confidential comparable sales information, you may have duties to both parties that require careful handling. Comparable sales are generally not confidential in the same way as a seller's private bottom line price or a buyer's maximum offer amount. However, dual agency is never simple. If you believe comparable sales may become an issue, discuss it with your broker and address it clearly with both parties before problems arise. The safest practice is to avoid surprises and make sure both clients understand what information can and cannot be shared. Compensation does not reduce fiduciary duties. Another important issue involves compensation. Suppose you are representing a buyer, but you never discussed compensation clearly. You discover a property that fits the buyer's needs, but the seller is not offering compensation, or the compensation is less than what you expected. Can you simply avoid telling the buyer about that property? Be careful. Once you represent the buyer, your fiduciary duties are not reduced simply because compensation is uncertain. The lack of compensation does not automatically lessen your duty to provide relevant information to your client. This is exactly why the BBEEA matters. The agreement should explain compensation clearly before you begin working with the buyer. If the seller does not pay, the buyer needs to understand whether they are responsible. Without that conversation, the relationship becomes unclear and risky. Confidentiality after agency ends. One of the most important lessons in this course is worth repeating. Confidential information remains confidential even after the agency relationship ends. If you previously represented a seller and learned their financial distress, minimum acceptable price, family issues, or negotiating strategy, you cannot later use that information against them simply because the listing expired. The same applies to buyers. If a buyer told you their maximum purchase price, motivation, financing limits, or personal circumstances, that information remains protected unless the client authorizes disclosure or the law requires it. Your duty of confidentiality is one of the reasons clients trust you. Do not treat it casually. The big lesson: legal issues in agency usually come down to clarity. Clarify who you represent. Clarify when agency begins. Clarify how compensation works. Clarify whether dual agency exists. Clarify what information is confidential. Clarify what documents must be signed. The more clearly you handle these issues at the beginning, the fewer problems you will face at the end. Good agents solve problems. Great agents prevent them. Broker tip: when an agency or compensation issue feels uncomfortable, do not guess. Call your broker before taking action. A 5-minute broker conversation can prevent a 5-month dispute. Online discussion question: why should agents be careful about making a BBEEA too narrow? Answer: if the agreement is limited too specifically by location, property type, size, or other terms, the buyer may later purchase something outside those limits, and the broker may have difficulty enforcing compensation rights. Question: why is a broker generally not required to reduce commission just because a seller threatens not to close? Answer: the commission was negotiated in the employment agreement. A seller's refusal to close may create a breach issue, but it does not automatically require the broker to give up agreed compensation. Question: why does compensation uncertainty not eliminate fiduciary duties? Once agency exists, the broker owes fiduciary duties to the client. Those duties are not automatically reduced because compensation is uncertain or because a property may not offer compensation.